On the two most divisive issues, abortion and affirmative action, she found a way to split the difference. She discarded the unworkable trimester system of Justice Harry Blackmun's majority opinion in Roe v. Wade to preserve a woman's constitutional right to an abortion while giving the states significant leeway to limit it. Similarly, she did not close the door on using racial preferences in hiring, awarding government contracts, or school admissions, but she steered institutions away from explicit quotas and narrowed the circumstances when race could be a factor. She rejected rigid formulas. O'Connor was a staunch conservative when it came to the power of the executive to wage war, but she did not believe the president's power was absolute. In the Hamdi case in 2004, she argued that the government could not just lock the door and throw away the key on the war on terror prisoners. A state of war is not a blank check for the president, she wrote, with a rare turn of phrase. A firm believer in the separation of powers and the role of an independent judiciary, she emphasized that the courts have a role to protect individual liberties even in times of war. Her critics complained, with some reason, that her avoidance of inflexible rules made it hard for lower court judges and litigants to know what the law is. O'Connor liked vague, reasonable man standards, and her successor, Justice Samuel Alito, pointed out that the answer to the question of what is reasonable sometimes turns out to be whatever the judge says it is. As a person, O'Connor she would be the first to admit directive. She told her law clerks not to chew gum and when to exercise. But as a judge she was modest, humble, a minimalist. She didn't like to go around invoking great jurists as her avatars, but she implicitly followed the model of Judge Learned Hand, who said that the spirit of liberty is the spirit which is not too sure it's right. She was keenly sensitive to unintended consequences, that hard cases can make bad law. Most important, she understood that the highest court in the land was not some Olympian last word, but rather a critical participant in an ongoing national debate over right and wrong. She was perfectly content to send questions back to the lower courts or political institutions to let the debate go on, to allow consensus to emerge slowly. More News Pulse news stories on the Supreme Court. Both sides on abortion agree, Roe is in play now.